Hello and welcome. If you're facing a penalty from HMRC, I know it can feel pretty overwhelming, but trust me, you are in exactly the right place to get a handle on it. We're about to walk through how to appeal, step by step, using a fantastic guide put together with some of the sharpest minds in the tax world. That's right, this whole session has been developed with the brilliant experts over at My Tax Accountant, who are, as you probably know, one of the UK's top accounting firms. Their insights are basically our map for getting through this. Okay, let's get into it. Yes, the brown envelope. You know that feeling, right? Seeing that thing on the doormat can make your stomach just drop. It's a feeling that so many freelancers and small business owners know all too well. It can feel really personal, but it's important to remember it's just a process, and it's a process we can absolutely navigate. And just to make things a little more interesting, the 2025 budget, which was announced today, has actually brought in a tougher new penalty system for this coming tax year. So, yeah, the stakes are a bit higher. But knowledge is power. The absolute key is not to panic, because there is a clear way forward, and we're going to walk that path together. So here's our game plan. We're going to take this one step at a time and turn that feeling of panic into a solid, actionable plan. We'll kick off by understanding the new rules. Then we'll get into the real heart of a successful appeal. And we'll finish up by looking at your options if that first attempt doesn't go your way. All right, first things first, we need to get our heads around HMRC's new penalty system. See, before you can even think about challenging a penalty, you've got to understand exactly what they're penalizing you for and why. And here's a little pro tip to get us started. A lot of people think these penalties are only for filing your tax return late, but nope. HMRC also hands them out for paying your tax late and for sending in a return that has some major inaccuracies. It's kind of like a three-pronged attack you really need to be aware of right from the start. Now, check this out. Under these new 2025/26 rules, the penalties escalate, and they do it alarmingly fast. It kicks off with an instant £100 fine just for being a single day late, but that's just the beginning. The real pain starts with penalties that are based on how much tax you owe. Just look at the 6 and 12-month marks. Penalties for late filing and late payment actually stack on top of each other. It's a financial spiral that's really designed to make you act, which is why understanding this is so important. And as if that wasn't enough, on top of all those penalties, HMRC charges interest. As of today, that rate is a pretty hefty 8.25%. You can think of it as, well, salt in the wound. So this isn't just about the flat penalty fee, it's about the ongoing cost of every single day of delay. Okay, so now you get what's at stake. Let's talk about your next move. The second you have that penalty notice in your hand, a really critical window of time opens up. And what you do in these next 30 days can make all the difference. 30. Remember that number. It is your absolute non-negotiable deadline. You have 30 days from the date printed on the penalty notice. And that's a crucial little detail. It's not the day you get it in the post, to get your appeal in. If you miss this, you've lost your automatic right to appeal. Seriously, do not put that letter in a drawer to deal with later.
So, what are your immediate first steps to take back control? Number 1, don't ignore it. It will not go away. It's only going to get more expensive. 2, file any outstanding tax return immediately. You can't really appeal a penalty for a late return if that return is, well, still outstanding. 3, if you possibly can, pay the tax bill. This stops that 8.25% interest clock from ticking. And remember, if your appeal works, you'll get it all back. And finally, number 4, start preparing. This is the moment to get your facts straight and pull your evidence together.
Okay, this brings us to the most important part of your entire appeal. This is where your case is truly won or lost. It is all about crafting a reasonable excuse. And stay with me on this, because what HMRC considers reasonable might just surprise you. So, what on earth is a reasonable excuse in the eyes of the law? Well, it's not just any old excuse. It has to be something pretty significant that genuinely stopped you from filing. The crucial part is this objective test that HMRC and the tribunals use. Would a sensible, prudent person in your shoes also have been prevented from getting it done on time? It's not about what you thought was reasonable. It's about what a neutral outsider would think. To make this a bit more real, let's meet Chloe. She's a freelance graphic designer in London, running her own little business. And she's just received that £100 penalty for filing her self-assessment late. So, why did she miss the deadline? Let's have a look at a few scenarios. This table illustrates the difference perfectly. A serious family illness, her computer dying right as she was about to file, a fire at her office. These are unexpected, major events outside of her control. Those could be valid excuses. But what won't work? Not having enough money to pay the tax is explicitly not a reasonable excuse for filing late. And here's where so many people go wrong. You cannot blame your accountant. HMRC is crystal clear. The legal responsibility to file on time is always yours. Your agent acts for you, but the buck stops with you. And look, these aren't just abstract rules. This quote here is from a real tribunal case that involved a bereavement. The tribunal recognized that going through a long period of extreme personal difficulty was a valid reason for letting your tax affairs slip. It just goes to show that the system can and does apply common sense and compassion to genuinely tough human situations, as long as the case is made well. So, the crucial takeaway here is that you absolutely must back up your story with evidence. An excuse is just a story without proof. If you were ill, you need a doctor's letter. If your computer failed, you need time-stamped screenshots. For a fire, you need a police report. Think of it like this. Your evidence is what translates your story into the official language that HMRC understands and, more importantly, accepts. Okay, you've got your reasonable excuse, you're gathering your evidence. Now for the practical part. How do you actually submit this appeal? You've got two main options here. For that initial standard £100 penalty, you can often appeal really quickly online or even over the phone. But for everything else, we're talking daily penalties or the bigger ones that are a percentage of your tax bill, you'll need to appeal by post using a specific form called SA370. And here's a quick did you know moment for you. A super common mistake that delays appeals is just forgetting to include key bits of information. You absolutely have to include your 10-digit unique taxpayer reference, your UTR, and the specific reference number from the penalty notice itself. Without those, your appeal basically hits a brick wall before it even gets started. When you sit down to write your appeal, be structured. Clearly state who you are and which exact penalty you're appealing. Lay out your reasonable excuse in chronological order with specific dates. And this is crucial. Explain what you've done to put things right since. And finally, keep the tone professional and factual. Be firm, but be fair. This isn't the time or place for anger or emotion. It's all about presenting the cold, hard facts of your case as clearly as you can. Now, let's be real. It is possible that despite all your best efforts, HMRC rejects your initial appeal. And yeah, that's disheartening. But I want to be very, very clear about this. That is absolutely not the end of the road. You still have some powerful options. Let's have a look at the escalation path. After you get that rejection letter, another 30-day clock starts ticking. And you now have a really important choice to make. You can either ask HMRC to conduct what's called an internal review, or you can bypass that step and appeal directly to the Independent Tax Tribunal. So, what is an internal review? Basically, it just means your case gets a fresh look by a different HMRC officer, someone who had nothing to do with the first decision. Strategically, this is often a really good next step, especially if you think a simple mistake was made or maybe you've got some new evidence to share. It's a chance for a second pair of eyes at HMRC to look at your case, and it's usually quicker and less formal than going to a tribunal. But what happens if the internal review also fails? Or maybe you just believe your case rests on a point of principle that HMRC is never going to agree with. Well, let's talk about the final stage, taking your case to the tribunal. This is probably the most important thing to understand about this whole process. The first-tier tribunal is not part of HMRC. It is a completely independent judicial body, just like a court. A legally qualified judge who has nothing to do with HMRC will hear your case and make a binding decision based purely on the law and the facts you present. You will get a fair hearing. Here are some quick facts to keep in mind. Generally, there's no fee to appeal. As we just said, it's totally independent. And while you'd normally pay your own costs, the tribunal can order HMRC to pay your costs if it's found they've acted unreasonably in how they handled your case. Now, that's rare, but it's a really powerful check on the whole system. This all leads to a pretty big question. While you can absolutely represent yourself, the tribunal is a formal legal setting with its own specific rules and procedures. So, is this the moment you should get some professional help? Before we answer that, let's just quickly nail down the key takeaways from all this. 1. Act fast. Those 30-day deadlines are everything. 2. Get your house in order first by filing the return. 3. Build your case on a solid foundation of a credible excuse, backed up by hard evidence. 4. Keep all your communication professional. And 5. Always remember that a no from HMRC does not have to be the final answer. Okay, now we have to be really clear on this next part. The information we've gone through today is for general guidance only. It is not, and it really shouldn't be seen as, a substitute for professional tax advice that's been tailored to your unique situation. And this is so important. Every single case is different. So before you make any decisions about your tax affairs or launch an appeal, you really must consult a qualified expert who can look at your personal circumstances in detail. Which, of course, brings us right back to that question of professional help and the experts who helped put this whole guide together. If you need that support, you can get in touch with My Tax Accountant. Their phone number is 0208-570-8531, and their email is info@mytaxaccountant.co.uk. And we'll just leave you with one final thought. Every single case that goes to the tribunal helps to shape how the law is interpreted. So, by standing up for a genuine and fair reason, you're not just fighting your own corner, you're actually part of a much bigger conversation. Who knows? Your reasonable excuse could just be the one that sets a new precedent.